So we were talking about international courts and tribunals, the way they settle the dispute. Although they are not alternative means of settlement of disputes, but when we were discussing about the settlement of dispute at international level, I think it goes well with us to understand how international dispute settlement is being conducted. So we were discussing about the ICJ, which is called the World Court, and the ICJ normally, the jurisdiction of the ICJ covers the interpretation and application of treaties, then sovereignty over territory and border disputes. If you see the World Court's function, there are many disputes which is being settled over the course of time related to the territorial disputes, West African case, then Namibia, uh, uh, the legal status of Namibia. That was another case before the ICJ. There were many more decisions, maritime borders and other measures related to the law of the sea. I'm sure many of you know about the North Sea continental shelf case, Libya Malta continental shelf, maritime delimitation case. So all these were settled in the ICJ. The use of force is one area. If you and I'm sure all of you know about what happened in the Nicaragua versus United States, that judgment, one of the fundamentally important judgment, and that deals with the use of force, violation of contracts, Barcelona traction case, I think, and there are many others. Principles of customary international law. These issue you will find in many of the disputes before the International Court of Justice, and the interpretations provided by the court in this regard goes beyond any saying that it's a fantastic area of study for anybody to go through, although it doesn't properly reflect to our courses, but I think we should understand the issues properly. Another mechanism for settlement of the dispute is another set of mechanisms, I would rather say, the regional agencies or arrangements, as Article 33 says that parties can settle the disputes through regional agencies and arrangements. So what does it mean when it says regional? Is basically geographical proximity or territorial cohesion uh, within a particular region. Uh, in the global orders, global societies, there are different organizations not taking global members, all global members. They actually form within a particular region, based on the geography, based on the ethnicity, based on the identity of different nature. uh, Mostly they are in the nature of a particular region, uh, based on their geographical what you call situations. And also I guess this is mostly like collective sense of collective security, playing a key role in terms of forming these organizations to develop bondage among the peers or members to enhance cooperations. But I think from every sense, as we belong to South Asian region, we are mostly in disadvantageous position, because the regional organizations in this part of the world is not working properly. Whereas in Europe, in North America, even in South America, in Southeast Asia, I mean, superb. If you look at the functions of regional organizations, Europe has been a very successful, uh, what you call, organizations in terms of projecting how it looks like providing citizenship, European citizenship to the individuals apart from their own state's nationality, which is another dynamic function, developing a currency of their own, and political, trade, and economic issues, the way they combat. By the way, I mean, many of you will be surprised to know that when there is a matter between any European country, European communities country, with other non-European communities countries before the WTO, so those countries in Europe do not defend themselves individually, rather they go with the organizations like European Council. So you will not find a dispute between China versus Germany. Most likely you will find a dispute versus, in World Trade Organization as China versus European community. So if, I mean, that is one of the strong message they try to give to the global communities in terms of their communities bondage. Well, Chapter 8 of the United Nations Charter is devoted to regional arrangements or agencies, and their role in dispute settlement is addressed specifically in Article 52. So the UN's Dispute Settlement Manual prescribes the resolution mechanism and procedures of the regional organizations, including there are many regional organizations: the Arab League, the Organization of American States, the Organization of African Unity, which is now African Union, the Council of Europe, the Conference on Security and Cooperation in Europe, the European Communities, which is now the European Union, and the Economic Community of West African States. These are some of the examples. Other than these, you have SAARC, you have ASEAN, you have BIMSTEC, you have East Asian organizations. And I think, yeah, there are abundance. One can keep naming all of them, but of course, somewhere we have to stop. Also mentioned the European and American human rights system. I think that's a very important area for us to look into, that how regional judicial system has, responding to different situations as well as contributing. For example, if you look at the European system, again, if I go to the European Court of Human Rights, this is one of the unique international regional dispute settlement body, because the European Court of Human Rights entertains disputes, uh, you know, of any European citizen who has been aggrieved by the decision of the concerned Supreme Court of that country. So you understand the level of the regional control over the countries. And here is the point, that when we're talking about the dispute settlements within Europe, they have made a supranational judicial bodies. For example, we cannot even think of any citizen of Bangladesh being aggrieved and by the decision of the Supreme Court, and then will be, collectively, or a citizen will be filing an appeal to any supranational regional bodies, and that's not happening here. So in Europe, that's possible under the human rights European Convention on Human Rights. So that's how they are dealing with it. And there are many others, like Inter-American Court of Human Rights, African Court of Human Rights. So they are also functioning quite well. Inter-American Court of Human Rights has developed tremendous uh, ranges of jurisprudence in human rights law, which is fascinating for others to study and know. Other than human rights areas, European Court of Justice is also a forum functioning in Europe between and among the European nations. So that's another areas. So there are regional bodies working and functioning properly, and these are the specific method of dispute settlement. right? I mean, if I start naming from negotiation, then inquiry, then mediation, and then conciliation, then arbitration, then judicial settlement, and then regional agencies and arrangements providing settlement of disputes. And then, of course, for the rest, please listen to the next part where we'll be discussing something more. Thank you.